Gosh, we've been busy this last month.
Yeah, no, and
Finally a break to talk to all of our friends about the interesting new cases that came out.
yeah. It's actually going to be a busy summer too.
I know. But we wanted to talk about this really intriguing decision. It's a lower court, a provincial decision from Saskatchewan. But there's some amazing commentary, and I think quite eloquent commentary, but important in terms of what we've talked about so often, which is the impact of the new legislation in sexual assault trials that complicate trials and create a heavy burden on both the accused and trial judges in determining what relevance and uses evidence can be put to if they're admissible at trial.
Yeah, I mean, it's an exceptionally well written. I mean, the judgment is well written, but the judge literally provides a commentary, which is essentially a paper with footnotes and everything.
Paper. Yeah,
it's very well done. This is His Majesty the King versus Ronald Larter, Larter, 2025 SKPC 11.
And the gist of the case is this is the case that involved a male accused.
Yeah, let's outline it.
He was like a counselor at a camp event. They went camping, and the complainant was a youth at this camp, and ended up, saying that she, it was kind of intriguing because it was a she biologically who identified as male, who now identifies as female.
At the time of the allegation.
At the time of the allegation, identified as male, and so went on a male camping trip, but ended up in his tent, and because she was afraid to be on her own, and then alleges that a number of acts took place that were inappropriate.
Yeah, it was a youth camping trip, and allegedly the complainant goes to the tent of the accused, and then while in the tent, there's unwanted touching and vaginal intercourse without a condom.
Alleged.
So these alleged very serious allegations.
Yeah.
The accused testified at trial and unequivocally denied the allegations, and his defense at times was, you can refer to as a bare denial because it's a categorical repudiation of the allegations. But there was interesting aspects to the evidence that the judge commented on, and ultimately found that the Crown did not discharge its burden of proving the allegations beyond a reasonable doubt, and he was found not guilty.
There's a number of bits of evidence that are kind of interesting too, because they relate to reputational evidence of the complainant being a troubled youth and having engaged in lies and deceptive behavior. And so a number of...
The youth camp happened to be this organization happened to be dealing with youth who were struggling.
Yeah, struggling with issues like that. And so the judge had a very big burden in terms of looking at the types of evidence being sought to be adduced and determining if they were admissible at court, what limits were placed on the weight that could be put on that type of evidence. And as a result of the complexity of this case, it resulted in what we think is really fascinating commentary on the legislation.
Yeah, so I want to just review this a tiny bit, but there's some opening remarks from the judge, which I think we have to read, because often we'll have people come to us and say, again, we say this a lot of times, well, it's a simple case. It's a simple case. And we try and explain.
There's no evidence.
There's no sexual assault case is simple. And I want to read this because, again, in the provincial courts in any province in Canada, those judges are dealing with the heavy lifting of the criminal justice system. They are doing the majority of trials, and they are seeing these cases day in and day out. So the judge says this decision is necessarily extensive, driven in part by the evidentiary complexities that demanded careful scrutiny to ensure a just determination. As will be explained, this reflects both the expansive interpretive lens through which evidentiary admissibility must now be assessed within the framework of various screening regimes and the increasing legal convolution surrounding these matters in sexual assault trials. The case exemplifies that reality, where a straightforward credibility analysis, what we refer to as the WD analysis, was engaged, legal consent was not an issue. A little to no corroborative or forensic evidence was available. Yet the path to resolution was anything but simple.
So just to pause, legal consent was not an issue because the complainant was underage.
Right, and this was a denial as well. So this was pretty straightforward. It was a denial case. It's an underage who couldn't consent in any event. There's no other additional evidence.
That means if they found there was sexual contact, that it would consent would be vitiated, even if it existed.
For a number of reasons. This is a counselor, but let's just keep it simple, because it was straightforward in that regard.
Yeah.
So consent wasn't a legal issue in this case. There was no other evidence for the court to hear, like forensic evidence, for example. Yet the judge noted the path to writing out the decision and coming to the decision was a complex one. Once relatively straightforward sexual assault trials have evolved into procedurally and substantively intricate proceedings, now stretching across courtroom calendars in a manner once reserved only for the most complex criminal prosecutions. What might previously have unfolded over days now demands a judicial investment measured in seasons, not sessions, encompassing protracted evidentiary hearings, layered legal arguments, and extensive judicial determinations, culminating in comprehensive legal reasons at nearly every stage. This extended adjudicative process places considerable strain on judicial resources and compromises the efficiency of the criminal justice system. If trial delay is to be regarded as, I've never heard this word before, anathema to the proper administration, I love that word, of justice, then the labyrinth complexity of sexual assault law stands as one of its most conspicuous and troubling manifestations. It's f***ing great. The strain it imposes, both institutionally and substantively, invites reflection on its implications for the equitable and timely resolution of criminal proceedings.
So let's break that down. It's beautiful.
First of all, I just want to say, excellently written.
Yeah.
And it captures the problems we face with this new legislation that came in 2018. And everybody pay attention to this. Sexual assault trials are highly complex, multi-layered adjudication of evidentiary issues involving intricate writing, not just from the judge when they're making their ruling, but in getting these applications drafted and served and filed and then argued.
But the choice of words, like even labyrinthian, like this is so important to understand. Like, we're not just talking about, hey, my job sucks because now I have to do extra work. We're talking about, as we'll get into further, that the jurisprudence on this and how judges have to be so careful about how they assess and how they deliver their reasons for what they allow or what they don't allow has become labyrinthian and so complicated that it brings into question whether or not the justice system is functioning properly.
Right, because it's not just how complex and difficult it is for all of the players, the barriers to access to justice, but does it impede a fair determination of the facts? That is a big question that I think still looms large here, even though the Supreme Court of Canada said this was all constitutional. Now, just to hone in on the case for 1 second, just briefly. So the judge relied on many aspects of the complainant's evidence in chief and cross-examination, noting where the complainant had become combative with questioning about motivations for entering the accused's tent. She repeatedly stated that she went there because she trusted him, despite having previously testified in chief. She did so only because she was upset about some hammock incident. Eventually, she asserted that she did not know why she went to his tent, other than she trusted him. There was some evasiveness and commentary which wasn't of assistance to the complainant's reliability and credibility. She would use terms on certain evidence, would have gone to his tent, would have used a flashlight, would have done this. So the judge...
So the difference between saying would have is it's not a clear memory of what did happen. It's a guessing game of what probably would have happened.
Right, because before in other respects she provided unequivocal statements, but this was qualifying language that suggested on certain important points she was approximating, speculating, rather than recalling with certainty the details she subsequently testified to. This is a pattern particularly problematic in assessing her reliability, and she later testified in cross-examination that she used a source of light of some kind, but would not confirm it was her phone, despite previously asserting it would have been the flashlight on her cell phone. The fact that she employed this conditional passive phrasing, even when describing the alleged sexual touching, contributes to my uncertainty regarding her testimony. The reason I raise this, you want to say something?
Well, no, go ahead, because I was just going to say that there's a difference between ultimately why he was acquitted and the reasons why the judge is commenting on the complications of
right. But it's a wonderful
evidence.
It's a wonderful juxtaposition because the judge was relying on simply analyzing the evidence of the complainant and analyzing the evidence of the accused, and noting in this case on important points. What one would have care about is this type of language used. It's this qualifying language used by the complainant while testifying that could demonstrate she was either speculating or not recalling with certainty important details. And therefore, you're looking at a fairly common type of analysis that a judge goes through in assessing credibility and reliability. And the judge fairly notes that the fact that she employed this conditional passive phrasing, even when describing the alleged sexual touching, contributes to my uncertainty regarding her testimony. So this, just bear with me for a moment. This is how judges go about traditionally analyzing evidence of a complainant, analyzing the evidence of an accused. But this was a lengthy, complicated judgment where you have to go through all these machinations or labyrinthian,
the matrix of
this yeah. Because of the legislation, because of case law. Mm-hmm. And that caused this judge to then provide a fairly lengthy commentary written exceptionally well. Should be an academic paper.
It should be.
On what's wrong here.
And you know, it's like without quoting too much just from it, like the wording of this is
I want to quote from it. This
so
is really good.
Yeah. It's worth reading out.
It's exceptional because you don't get a judge going out of their way at the end of an acquittal to say, you know, we really should think about this. Is very thought-provoking. Mm-hmm. And it's not a judge saying, I'm for one side or the other. We got to go into some of this.
Yeah.
Because it's an extremely thoughtful reflection on where we are now in one area of the law that's become so complex, it bears reflection.
It does. And so there's a section in this decision that's titled, it starts at paragraph 98, it's titled Inadmissible and Limited Admissibility Evidence, and then goes into an assessment of the jurisprudence and at times the lack of clear guidance from the courts of appeal and Supreme Court in terms of, and in fact, ever-changing interpretations of how these things are to be dealt with. So this is a section directly devoted to talking about these complications, which I'm going to go to 99. They say, in such a landscape as was created by the new legislation, it becomes essential to draw careful distinctions between inferences that have received judicial endorsement, inferences they can draw from the evidence, and those that fall beyond the bounds of permissible contemplation. A citation to a recent decision called 𝐸𝐿. Not necessarily because they're illogical, but because they are ideologically incompatible with prevailing orthodoxy. Okay, so this is important. This is a recognition that a lot of the legislation is brought about not by simply learning from the past or building on previous decisions, but there's an amount of orthodoxy and ideology that's involved in designing the legislation for political reasons. Patterns of reasoning, once deemed intuitive, even grounded in common sense, which we've joked around as like common sense has gone out the window until recently, they've been reclassified as doctrinal error, or worse, as jurisprudential missteps. Judges must therefore not only weigh evidence, but also vigilantly monitor their own cognition. That struck me as so important. So what the judge is saying here is not only do they have to care about the law, but they have to worry about what people are going to think about their mental process.
But read the rest. This is good. Ensuring that their evaluative processes remain within the parameters of the authorized interpretive matrix. Within this architecture, clarity of thought becomes less a matter of neutral inquiry than of disciplined adherence to sanctioned modes of analysis. Such is the cost of judicial error in a system that increasingly equates intellectual caution with legal correctness.
Sanctioned modes of analysis.
So let's just pause for a second, okay? And I know that this judge goes into talking about this, but let's just be careful for a moment. We absolutely understand and endorse the fact that the case law in sexual assault and domestic cases have evolved over time to root out discriminatory thinking and biases. Absolutely correct. And have come to carefully understand that not all people are created equal. People may react to things in a different way, and so much of what we regarded sometimes as common sense could be a discriminatory belief. But we were achieving
For
all
example, thinking somebody would scream and fight back or something like that. These are things, so you're talking about discriminatory,
or an abused person would still
about what a person would do.
Would still associate with an abuser, all of that. But these were things that we were dealing with carefully through case law. But the government got themselves involved. And what's most objectionable that we've learned to live with and use to our advantage was the fact that we are disclosing records and documents, much of which never would ever have to be screened by a court, right? Because it doesn't involve other sexual evidence, which judges would be adept at in any event if at trial would deal through relevancy. You have this screening
There's normal
process.
rules of relevancy in any trial, whether it's involving sexual assault or drugs or whatever. You can't just introduce frivolous evidence that's not related to the issues at trial.
But this is exactly what the judge is talking about when it's about prevailing orthodoxy. This was the prevailing ideology that was instrumental in creating the legislation, particularly with respect to the screening of all records, documents, etc., in the possession of an accused. That was a prevailing orthodoxy, an ideology.
As it goes on, it's within this carefully curated epistemic terrain. I mean, the wording of this is just amazing. Like
He's an excellent writer.
Paper. This epistemic terrain where sanctioned inferences are scrupulously distinguished from their impermissible counterparts. The procedural screening regimes governing sexual assault trials now operate. Well-rooted, and this is important, well-rooted in legitimate objective to eliminate discriminatory assumptions, these frameworks have gradually evolved into a complex architecture of procedural control, one that often dictates not only what evidence may be admitted, but how and even whether it may be considered at all. And that's one of the balances I found really intriguing about this decision too. It's not just a rant about the current
It's not a rant.
procedures. There's a recognition in here about legitimate uses of the legitimate reasons behind the new legislation.
The result is a jurisprudence increasingly defined not by what it permits us to know, but by what it forbids us to consider.
Right.
Say that again. The result is a jurisprudence increasingly defined not only by what it permits us to know, but by what it forbids us to consider.
Thought crime.
Yeah.
And this is one of the things that I think was a concern for a lot of judges as this legislation came out and before the JJ decision deemed it to be constitutional. The judges were increasingly becoming concerned about thought crimes and that when they write something, they have to word it precisely, perfectly, otherwise they'll be accused of wrongthink. And that still exists today, is what this decision is saying. And I think it's very apt. I think it's very well thought out and an important thing, especially for a provincial court judge to do, to put themselves out there and basically say what everybody can see. The emperor has no clothes, to some degree.
It is a careful reflection, thoughtfully drafted, about where we are now, years after the new legislation has been imposed. And the judge is correct in saying, the landscape of sexual assault law in Canada has undergone continuous and transformative change, ostensibly aimed at achieving better and more just results, specifically securing more convictions where warranted. Yet this evolution has not come without a cost. Where procedural barriers and evidentiary restrictions are imposed, as prophylaxis against improper reasoning, trial judges are tasked with the dual role of gatekeepers, controlling the admissibility of evidence, and triers of fact, assessing its weight. However, the expanding rigidity of these constraints calls for reflection on whether exclusionary safeguards have begun to overshadow the imperative of fair adjudication. So this is where this is where I'm driving at more than anything. Let's move out of this type of academic writing for a second and bring this to an example. Mm-hmm. We have many applications we bring to court, and we argue about things that should be admitted or areas of question that should be allowed. Do we consider it almost ridiculous that we're arguing this? And we meet with arguments from sometimes Crown attorneys, and I have said that of late, we've had very good, thoughtful responses from Crown attorneys who've read the material, but there are still some that are boilerplate responses, just opposing anything and everything.
Just deny everything.
Just for the sake of doing it, without thinking about whether that's appropriate or not.
Yeah.
And we get into dumb arguments where complainant's counsel will argue the scorned woman doctrine or all sorts of other bullshit.
Meaning like saying, oh, just because she appears to be a scorned woman, that's a myth.
Yeah.
So
and therefore nothing should be allowed.
Even if it's true.
With no analysis in these responses. Particularly when we're talking about areas of cross-examination that are clearly relevant, clearly probative, and documents that are clearly relevant and clearly probative. It's ridiculous. Mm-hmm. We have, fortunately, had very thoughtful responses that we've had in many of our cases and proceeded in many aspects on consent. But we have met with these arguments against relevant materials that's ridiculous. This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record, and now back to our podcast. Thank you.
Yeah, well, like it stands out to me too, saying like they talk about more just results and just being in scare quotes, specifically securing more convictions where warranted.
But where warranted.
They say where warranted, right? Yeah. But then a point is made in this is that desire to secure more convictions can have this, unfortunate consequence of denying legitimate evidence and resulting in wrongful convictions.
That's where the judge's comments that the expanding rigidity of these constraints calls for reflection whether exclusionary safeguards have begun to overshadow the imperative of fair adjudication. In other words, we may be arguing and excluding evidence because of these rigid considerations that's relevant and will obscure a fair adjudication of a case, therefore leading to a wrongful conviction. This is a legitimate concern of a judge at the end of a trial who rendered an acquittal. And it's one that I think most people in the justice system don't want to talk about or would take the time to talk about.
And, he goes on to say, that the higher courts have consistently affirmed the necessity of these screening regimes. They've upheld them as constitutional.
Well, the Supreme Court has, obviously.
Supreme Court has, yeah. And protecting complainants, preserving fair trial rights. Practical implications of their operation are far-reaching. The requirement to pre-screen potentially contentious evidence, often well in advance of trial, and in some cases, such as this one, on an emergency basis, mid-trial,
right.
Fundamentally reshape litigation of sexual offenses. So one of the points to make in that, and we've talked about this before.
But I love the next sentence. The procedural choreography now demanded of counsel and judges reflect both the embedded ambiguities and the entrenched rigidities within this legal framework.
Yeah, and so, but there's an important point there is that these applications need to be brought pre-trial, which means we need to predict what the trial evidence is going to be. And, that's to some extent unfair. And we've had, a bunch of, responses to these applications saying, oh, well, we're not going to lead that evidence. Okay, well, fine. But we have to bring the applications assuming that it will be led if the complainant said it in a statement, right? So that's one of the things that I think hasn't been addressed properly, is that we need to predict the future of what's going to be said at trial when we bring the applications, in order to try and prevent these emergency mid-trial applications.
Right. So, in some cases, we have more fruitful pretrials than others, where we can address with Crown attorneys what evidence they intend to call. And sometimes you can get very compelling, concessions not to call evidence that you can rely upon. But many times you're doing pretrials, judicial pretrials, and setting up the trial, and you're not sure whether the Crown is going to call this evidence or not.
We have to assume that they're going to testify the way they gave their statement.
And so we go through all of the possibilities that what evidence will be called, how it'll be interpreted, and how we need to deal with it in these applications. And then sometimes in responses, the Crown will say, well, I'm not going to call that evidence because that's clearly bad character evidence or prior discreditable conduct. And we'll go, well, that's exciting. But we don't know whether your complainant's going to say that.
I always love it when you say,
yeah.
Well, that's exciting.
Well, we don't know if the complainant's going to say that or it's going to come out. And if we don't say it now, we don't want to be blamed later on for not raising the issue. Right. So I'd rather raise the issue. But that requires us to think ahead of every possible fucking chess move that could occur in this proceeding and make sure we're dealing with it. Everything.
But the trial judge goes on even further in this decision, because this isn't just a pretrial motion decision. This is an actual decision of the outcome of the trial. But made it clear that as a result of all of these new expectations on the trial judge as the gatekeeper, having heard all these applications, decided what's admissible, that a huge portion of this decision had to then be devoted to discussing what could not be considered and things that could be considered, what the limitations were on how they were considered, the weight that was put on it, and the limitations that were put on it. So the burden isn't just in having to do the pretrial motions, but on the judge in their decision to make it clear that they didn't rely on material that they shouldn't have relied on.
Yeah.
And, I'm just saying, basically saying, I could have written this a lot easier, but because of the new jurisprudence, now you've got this extra, 50 paragraphs because I have to.
Yeah.
In order to not be accused of rapeness.
Or not even that. Or encroaching upon the privacy interests of the complainant. Let's give a concrete example. There's a case that's going to go to trial soon where there is a recorded conversation where the accused records a conversation of a complainant who later on accuses of sex assault. The recorded conversation is him confronting her about using a baby monitor to spy on him speaking.
Her using it.
Her using it to spy on him speaking with some other woman. And she doesn't tell him the truth about it. And he confronts her about it. And she's not telling the truth about how long she was spying on him, but then eventually admits it. And they have a conversation about it. And he feels that his privacy has been invaded. And she admits and apologizes, which is fine. Good they had that discussion. But it's relevant. It's relevant to motive to fabricate. It's relevant to her reliability and credibility in the sense that it shows that she's willing to do surreptitious things like spying.
Well, it was so weird because they argued, the complainant's counsel argued that it was a surreptitious recording, therefore violated her privacy. Yet the conversation was about her violating his privacy by using a baby monitor.
Well, I wanted to get to that. I just wanted to set it up. It's relevant to what we said also was her ongoing jealousy and anger at him for cheating on her and doing other things, which led ultimately to the context of why she went to the police and gave the statement she did, which led to his arrest. So this was him recording this conversation that she didn't know about. And we have the actual recording and we transcribed it, and that's evidence we want to rely upon because it goes to her honesty, her truth-telling, et cetera, et cetera. Now, the argument that we face from complainant's counsel, now take it slowly so they understand. This is one of the examples of the shit that we go through.
One, even though the complainant was caught surreptitiously spying on the accused, the argument was that it was inadmissible because it was surreptitious on his part to record the conversation about her behavior. But
yeah. So one of the arguments was that he surreptitiously recorded their conversation that invades her privacy rights, and therefore, because of it surreptitiously recorded, it should not be admissible.
Even though the conversation was about her surreptitiously spying on him.
But he can cross-examine her about this conversation, but we can't use the recording.
Right. That was an interesting aspect. So what?
No, I don't want to use an actual record to cross-examine a complainant. Should she choose to say other things, we would want to impeach her with it. But let's exclude the entire accurate recording of it. Like
it's real-time evidence that's more accurate to what was taking place at the time than the testimony given years later.
And the obvious thing is that I'm not asking to put in the recording as evidence itself. It becomes relevant in cross-examination when I ask questions about what she did, and if she deviates from the truth, then we can impeach her with the recording. It's obvious. But the argument
we've seen this a number of times where they say, well, you can cross-examine. I don't see why you need the actual, text message or the actual
recording. That's right, because it invades their privacy, because it was surreptitiously recorded. Well, surreptitiously...
Because it's accurate?
She fucking spied on him.
Yeah.
Right, why it's accurate? So this is a perfect example. Okay, so we spent considerable paper, okay, drafting this out, responding to this, 2 responses, argument, and then a ruling, okay? All for something that's pretty fucking obviously admissible. That's a good example of what we're talking about here. These entrenched rigidities within this legal framework can lead to important evidence being excluded because of these rigidities, because of the ideology that's in place. The idea that the privacy interest of a complainant trumps the right of accused to a defense.
And like the judge,
on relevant grounds.
And like the judge eloquently said, is like judges are being told we're gonna try and assess what your mental process was in making that decision.
You have to be constantly monitoring your cognition. Now, I get where a judge can't stray into impermissible reasoning, discriminatory reasoning, or say things that but these are trained experts. They were lawyers, they're judges, they go through training, they know the law. It's not like there's this overabundance of fuck-ups, by judges on this evidence. They've been dealing with this ever since we've had trials. And they've been doing a very good job of screening out discriminatory evidence and discriminatory cross-examination, irrelevant cross-examination without this fucking regime.
And sure, you can go back over the last couple of decades and pull up a case where something improper was admitted into evidence. Of course you can do that.
There's only thousands of these cases that go on.
I know. Those are the rare moments. I really think they're quite rare now.
Go ahead.
There's another aspect to this decision too, which I think is quite important, and it's been dealt with in a few other cases where the Supreme Court has been asked to redact
transparency,
hearings so that people can actually have access to why a decision was made and something was granted or not granted, and that goes into the transparency of the system, and that a lot of information that's withheld from court, the public has no access to know what was withheld or why it was withheld because of this regime that's put in place. And that's really important
too.
Well,
expand on this. So let's explain to everybody. So your screening regime requires a stage 1 motion and a stage 2. We've spoken about this a million times in our podcast.
That are in camera and the public cannot attend.
That are in camera. That expression means the public cannot attend it. The only people who can attend is the judge, the court reporter, the court clerk, defense counsel, and people from his office who work for him, the accused, the Crown, and, the complainant if she wants to show up, and then on stage 2, complainant's counsel. That's it. And judges have actually sealed the fucking record in cases.
And asked
so
for,
that you can't get a transcript of it.
And asked for the decisions to be sealed.
Well,
in some cases.
Yeah. So there is a significant lack of transparency with respect to the judicial considerations that went into why something is admissible or not admissible.
And of course, some of these cases where a lot of this stuff is being sealed, then, there's the media may go and report on an outcome of a case and the public doesn't know what they weren't allowed to hear. And that can skew their understanding of the outcome of the case.
It absolutely will. So the judge makes an important comment. While these protections serve important privacy interests, they also obscure from public view the full scope of what is excluded from judicial consideration, limiting transparency and diminishing the public's ability to meaningfully scrutinize the process through which justice is administered. These transparency constraints reflect a deeper structural issue. The law in this area has grown technically convoluted and in some respects inimical to the truth-seeking function it is meant to serve. Adversarial evidence screening motions are mandatory to determine the admissibility of evidence that would otherwise be plainly relevant, and even when all parties, including the Crown, agree that such evidence should be admitted, it is nonetheless categorically excluded if any procedural requirement is left unmet. This occurred in the present case, in which the email describing the so-called 𝐕𝐈𝐃𝐄𝐒 incident, which, although tendered by consent of the parties through an ASF, an agreed statement of fact, was ultimately rendered inadmissible due to non-compliance with the applicable screening regime. The statutory framework affords no discretion in this regard, leaving little room for pragmatic judicial resolution once the trial is underway. This is important.
Mm-hmm. Yeah, so even where the Crown is agreeing with the defense that certain evidence is admissible, they even do an agreed statement of facts, the trial judge then has to consider whether or not they can agree on those things.
And this is why, when some people wonder, well, why'd you put that in your application? Because we do not want the chance that later on at trial, somebody says you did not go through the procedural requirements, therefore it's not admissible. We can't take that chance with our client's life.
Procedural requirements, it has to be in writing. It has to be given in notice to the Crown and to the complainant's lawyer. Like, there's a bunch of practical steps that have to be taken in writing that are very difficult to meet. A judge can waive the number of days required if it happens mid-trial, but it's very complicated. And when our judicial resources are so limited, court time is so limited, if you have to stop in the middle of trial and bring a written application and then try and find complainants,
well, try and do that in front of a jury.
Yeah, exactly.
Right. So this bears repeating, okay? Adversarial evidence screening motions are mandatory to determine admissibility of evidence that would otherwise be plainly relevant. And even when all parties, including the Crown, agree that such evidence should be admitted, it's nonetheless categorically excluded if procedural requirements are left unmet. That is why we say, I know you may think this is simple, but it's not. And we have to draft out very carefully every single piece of evidence that we want to be admitted, whatever record, whatever fact we want to try and put in that may be caught by this screening regime. Mm-hmm. Because the alternative can lead to a wrongful conviction.
And to assist the judge in feeling confident that they're not allowing improper information, because, we lay out what the rape myth would be and why it's not a rape myth and all this other stuff. But judges really appreciate written submissions, and fulsome applications.
I can't blame them.
It helps them to be more assured that they're not falling into a trap that could somehow tarnish their reputation.
Somebody got mad at me because we had a podcast some time ago where the judge clearly made mistakes about, it was a Court of Appeal decision of a trial judge who clearly made mistakes about ungrounded assumptions of how the accused would have behaved or some cultural issues. And I had said in the podcast, one can forgive judges in some respects because there are, it's a difficult job. And somebody wrote saying, I'm just making excuses for judges and, went after me. And I'm like, okay, hold on. It's not a fucking easy job. I mean, you can see that this judge is trying to explain about the complexities that's involved. And that's why we said in that podcast, written submissions is extremely important because we want to try and get it right, especially for our client, of course, right? And it is a difficult situation where judges are having to go through this layered analysis to be very careful about what things previously would be much easier to navigate. And it's not that way, particularly because of the legislation and the ideology that's in place now. That's important to note. And when they want to place blame, it's very funny. I'm like, lawyers didn't do this. We didn't fucking do this. Crown attorneys didn't necessarily do this. Your fucking government did it. The people you elect. Those that talk about, we want tough on crime policies, there's too many people getting away with sex assault and this and that and other things. Okay, well, again, like I've said, everybody talks about this until they come to our office and it's their family member, their friend, or their loved one, or whatever. But it's your government. It's the politicians under pressure of lobby groups and others. That's who does this shit, right? This legislation came in because a certain prime minister and a certain justice minister did not like the result of a certain trial.
Yeah.
Right?
And, people just assume that, where there's smoke, there's fire and stuff. And we've said this before. One of the first things we usually hear is, I never thought this could happen to me. And it's like, yeah, well, you need to protect other people's rights, because that's protecting your own rights. Their rights are your rights. And we have to be very careful, like this judge says, the lack of procedural flexibility leaves participants confronting a stark and often unpalatable choice, engaged in protracted and often duplicative legislation over admissibility at multiple junctures of trial. Or they can accept the exclusion of potentially decisive evidence. They're saying, like, if somebody is not capable, and sometimes financially not capable of paying for all these motions and stuff, actual admissible evidence that could be important to trial could be excluded improperly.
And we're going to tread into one thing that the judge said that maybe might cause a little controversy, but paragraph 111, I just got to read it. The evolving procedural and evidentiary rules governing sexual assault trials have induced new layers of complexity, giving rise to practical challenges and interpretive tensions. Long-standing evidentiary principles and common sense inferences routinely applied in other criminal proceedings and are now subject to heightened scrutiny and, in some instances, recast as impermissible stereotypes when applied in this context. Trial judges must navigate a specialized legal framework that prohibits reliance on discredited assumptions while permitting certain inverse inferences. In this case, the complainant's failure to scream, avoid the accused, or disclose the incident promptly could not be weighed against her credibility. As such, reasoning is deemed reflective of stereotypical assumptions about how a real victim should behave. Yet, the complainant's expression of emotional distress, such as feeling awful, making distressed eye contact with the accused, and expressing a desire to cry during the
return drive.
Thank you. Was treated as relevant, probative, and corroborative evidence consistent with the expected emotional response of a sexual assault victim. Likewise, the accused post-incident conduct, layering his clothing, sleeping apart from the complainant, and composing a private email under cover of a sleeping bag was interpreted as indicative of a guilty mind. These asymmetries, though well-grounded in meaningful safeguards, are difficult to reconcile with principles of evidentiary consistency, impartial adjudication within a unified and coherent legal system.
That inverse situation is so important to have clarified in here. So a judge is permitted to and encouraged to take into account that a complainant says that she was upset and distressed and crying, and that therefore is supportive of a sexual assault allegation, but cannot take into account a failure to do such things.
Yeah, and so we're very careful about, and as it should be, that there is no way a real victim will behave. That said, there is intuitive relevance to how an alleged victim might behave in certain instances. So, for example, a camper who's raped viciously by a counselor would be seen within an hour or two laughing and joking and running around and doing things and interacting with the counselor might be f***ing relevant.
Yeah, but it depends on how they describe their own behavior.
Well, you have to ground it in what the character of that person is. But leaving that aside, one might find, and I might get beat up for this, but one might find in certain instances after the alleged incident behavior may be totally inconsistent with what real common sense will tell you about how somebody would behave in those circumstances. And there are different circumstances. We understand, again, of course, and endorse the fact that a complainant within a relationship will behave in certain ways because of the nature of the relationship and many other factors. But there can be certain instances where their behavior is inconsistent with what common sense would dictate. And that is relevant. But these inverse allowances or inferences are a real problem.
Anything could be taken as supportive of an allegation.
Now, we're careful to raise these as myths as well.
But yeah, and there's some experts, which we've talked about before, who come in and say that all the things that don't intuitively make sense, that go against common sense, are actually also proof of trauma.
Yeah, thank God that's probably gone now.
One of the other things, just for closing.
I know we're going long. How long are we on this one?
45 minutes.
I'm sorry. Okay, just one more. I love this paper. Okay, I'm going to call it a paper.
It should be a paper.
This paper is outstanding. These asymmetries are further compounded by the evolving and unpredictable treatment of other sexual activity in private records, which remains in a state of perpetual flux under the evidentiary screening regimes. Each new appellate ruling recalibrates the legal boundaries, often blurring the line between permissible probative use and impermissible myth-based reasoning. The distinctions between admissible and inadmissible evidence remain elusive, rendering predictability difficult, if not impossible. The uncertainty leaves counsel struggling to anticipate which evidence will be deemed admissible, prompting preemptive or unnecessary applications on the one hand and inadvertent omissions on the other. The result is heightened ambiguity, resource-intensive litigation, and an increased risk of evidentiary error, with trials increasingly consumed by contested applications that often overshadow the substantive issues in the dispute. You're absolutely correct, Your Honor.
That uncertainty is important, and like in the next, just to summarize the next paragraph, which I thought was really good. It's like they said, in tandem with the uncertainty created, there's a problem in that interpretations and new decisions coming out actually are increasing ambiguity about how judges are meant to make decisions. And in fact, they're very clear in the Supreme Court that it's up to the judge's discretion. That doesn't help judges understand how to navigate the complexities that have been introduced.
Right, and let's go back. Let's just circle back for a second, okay? So we are finding, I think, that there is more consistency with certain types of evidence that will be found to be admissible than there is uncertainty, simply because there's a fairly good body of law to argue, but also you have to craft your argument and ground it in the logic of the case, how it's relevant to an issue, and to the things that are said by the complainant.
As well as the anticipated evidence of the accused and why it's relevant.
Excellent point. You're right.
To what their version of events
so that you have the building blocks of their defense. But let's go back to transparency. That's the circle back I want to do. Judges are not always getting access to judicial determinations on these motions. They're not regularly posted on 𝐇𝐎𝐏. Because of this screening regime and the lack of transparency, you don't have these rulings abundantly available. We could have thousands of them.
It was more common before the JJ decision when judges were relying on each other's decisions to figure out how to interpret it. But once the new legislation had its official challenge at the Supreme Court, now there's been a dearth of decisions published.
There's a few. We find a few, and a few of ours have been reported, but often they're not. Yeah. And we've done 55, 56 of them. I got to tell you, about 47 of them are really helpful.
But most of them aren't published.
So you won't have assistance for judges in that respect. So the lack of transparency adds to the ambiguity and unpredictability of this. I'm sorry, I preempted one more point you wanted to make in closing on this. I apologize.
Well, no, I was just talking about the request from this judge, and it really should be turned into a paper. But for consideration about how the courts need to help judges interpret the legislation and apply it in a consistent manner, because it's really problematic when. But in my respectful view,
consistent with fairness to the trial and letting relevant evidence be admissible.
And the transparency
that is something we must stick to.
The transparency of the public about what types of evidence are being blocked from trial.
Yeah.
Which may be, as this judge says, is concerned that relevant evidence is being improperly blocked.
I really commend, to other practitioners, reading this, because it's a case that can go under the radar. We put it into our newsletter.
Because it's a provincial court decision.
Extremely bright judges are in all provincial court level courts. As I said, they're doing the heavy lifting across this country. And this is a very good reflection and caution that we should take under consideration seriously when we're thinking about where we go from here. Because there are arguments that are ridiculous. And there are rulings that are unhelpful to the truth-seeking process, but frankly, to a fair, just determination. In many respects, frankly, to stand against a wrongful conviction.
And, and judges
Excellent case.
Judges, people think that they just kind of show up and don't really do much, but they're swamped right now. The overload in courts, they have to try and make these rulings while also hearing other cases.
Just imagine, I'm sorry if I stand up for judges. It's not an easy job. Former associates of mine are judges, and colleagues and friends are judges. Excellent people, and they work really hard, and mistakes are made. Yeah. This judge didn't have to spend a long time. That wasn't written in 5 minutes. This judge spent time carefully drafting out this commentary, doing footnotes.
And trying to help people understand the unnecessary burdens placed on.
Right. I mean,
On
but
judges, yeah.
this
In
judge
the system.
took the time to draft what I think is an extremely well written, somewhat complex piece of analysis, when I'm sure he has tons of other decisions that are waiting, and he worked late at night and probably on a weekend or two to get this done for a very important reason.
It was eloquent and apt.
All right, that sounds good. Pillow Talk.
Hey, don't forget to like, subscribe, comment, share, tell all your friends. We do actually read the comments.
And thank you, Easy DNS, for sponsoring our program. Good night. Again, keep sending in any questions, comments, or ideas for our podcast. We do pay attention to it. And we thank you very much for viewing. Have a good night.